Okay, we're live. So welcome. Welcome to the SOA at Home Festival. This is your top membership FAQs answered. I am Nadia Bonini and I work at the SOA as membership manager. And I will host this event today. And yeah, welcome everybody. I can see that someone is already using the chat. This event is part of the SOA at Home Festival. This is a festival that runs for 12 weeks. It has started in April and this is the final week. All the previous recordings are available on the Vimeo channel of the SOA. We can post the link in the chat later so that you can see all the previous events. This particular panel session will last 45 minutes. We will have a Q&A at the end of about 15 minutes, and you will be able to ask questions to our panelists, but also feel free to interact using the chat throughout the event, and we can always pick up the questions later. There's only one thing I just want to ask you, please make the questions as generic as possible, because if you have some very specific personal issue, then you should email the SOA directly and we can deal with those there. This is more something that should be useful to all members. Okay, hello. Okay, I see that people come from everywhere. That's nice. If you have any connection issues during the event, there should be a big red button that says reconnect at the top of your screen. So just press that and that should do it. Or maybe just refresh your browser. That should also help. Right. So all these sessions are free, but if you can afford to donate even just a few pounds, please donate to the Authors Emergency Fund to support authors in financial difficulty due to the health crisis. To do that, please follow the link that should be on the sticky note at the top of the chat. You should see in yellow, and we'll be very grateful if you could just give us a hand with that and help other authors. And I think we're ready to start. So our panelists today are Theo Jones and Eddie Reeves. Hello.
Hi.
Hi.
Theo Jones works as a contract advisor for the SOA, advising members on publishing contracts and issues, and he's also the co-secretary of the Scriptwriters Group. Eddie Reeves joined the SOA in February 2020 as our campaigns and public affairs manager, having previously worked as a solicitor. He takes a keen interest in our contracts and member advice work alongside his day job leading on our policy and campaigns. So why did we decide to host this event? So the SOA was established in 1884 to advise individual members and lobby for the interests of authors. And we have represented and advised different types of writers for over 100 years now. And we have noticed that many of the principles in advising them are pretty much the same. So we thought of putting together a list of the top frequently asked questions that we receive every week from our members. And of course, with time, things have changed. For example, with the introduction of self-publishing, but also audiobooks and ebooks. And we will see some of these things during this discussion. And one final thing before we start, remember that part of our job, and specifically part of our advisor's job, is to simplify technical issues and help members understand the implications. So if during the discussion you have any follow-up questions, please feel free to ask. That's what we're here for. And we will pick them up at the end during the Q&A. So we can start with one of the, I guess, first questions that the authors ask early in their career. And that's, I've written a manuscript. How can I protect my copyright? Theo, would you like to start on that?
Yes, thank you, Nadia, and welcome everybody. Well, the good news is that copyright arises automatically by operation of law the moment original expression is fixed in a tangible form. So that's essentially words on a page. And it arises to the first owner, and that's usually the creator, so that's the author or the photographer, with a few notable exceptions, for example, a work created under a contract of employment. The law is largely enshrined within the Copyright Designs and Patents Act of 1988, have been amended subsequently over the years, And it works by reserving to the creator of original work certain exclusive rights relating to the handling and dealing of that material. So that would include the right to adapt the work and the communicating of that work or any adaptation of it to the public. Now, those exclusive rights are infringed when a third party makes use of them in relation to a substantial part of the work without having the authority to do so. So that could be the permission of the rights holder or someone authorised to grant rights on their behalf, e.g. their publisher. Ultimately, it is important to note that whether or not infringement has occurred will be a matter of fact and degree to be determined by the courts. And since copyright arises automatically, it follows that there is no requirement that works are registered in order to be afforded the fullest protection of law, and the UK authorities do not maintain such a register. Whilst there is likewise no requirement per se that copyright ownership is acknowledged within a work or in association with it, whether with the ubiquitous copyright symbol or otherwise, this is strongly to be recommended. You would generally expect to see wording of the form copyright, the C within the circle, your name, date of publication, all rights reserved.
Thank you. Eddie, do you have something to add on this?
Yeah, I think Theo's given a really clear summary of what copyright is and how you can go about protecting your intellectual property, particularly as a new author when things are perhaps not entirely clear. I like to think about it in these terms. Interestingly, copyright doesn't protect your ideas themselves. There's actually no copyright in an idea. All it does is to protect an author against someone else independently expressing that idea where it's been recorded in, say, a manuscript. So it's really from that copyright, that protection against someone else independently expressing your idea, that you enjoy the right as an author to license others to do certain things with your work, whether to a more or less limited basis. It's therefore a very strong and very flexible right to hold, I think. As to the act that Theo mentioned, the Copyright Designs and Patents Act of 1988, it's long been recognised in the UK as being something of a piece of analogue legislation, really. Certainly since 2015, there have been calls to update it and to have a proper Copyright Act that's fit for the 2020s. And one of the things that the SOA's been very hot on in terms of campaigning is for the UK to implement the EU Copyright Directive, with which the other 27 EU members will have to comply by the 7th of June next year. Now, given our departure date as the UK, we won't be obligated to implement that directive. So there's a really doubly strong case for a UK-specific Copyright Act that is up to date and that really catches all the permutations with this increasingly online age in which we're living. An age in which, incidentally, it's harder than ever to make a living as a creative professional, but easier than ever to have your creative work copied without your consent. I think probably that's all I would say for the time being. We can always return to it as we progress.
Yeah, and I think that we'll touch on it again. In the meantime, Karina asked, what about copyright on illustrations? Would you like to add a few words about that? I know we also have a guide on it in our on our website. So, and actually we have many guides on our website. So I would invite everybody to have a look on the guides and articles section of the website. It's very, very useful. And sometimes when a member emails in, it's already the answer to that question is already written there. So I just send a guide sometimes, and that just serves a purpose. So please do have a look. But we can touch on copyright illustration maybe later during the Q&A. And actually connected to copyright again, a frequently asked question is, how do I stop someone stealing my idea or my title?
So this is an interesting one because it's actually not a question of copyright. As Eddie has said, the copyright legislation is designed to protect the expression of an idea and not the idea per se. However, there is a protection that you could rely on, and a lot of the time we see this question asked in the context of a so-called non-disclosure agreement. Now, a non-disclosure agreement is very much the high watermark of level of protection, and its purpose is to bind a party or parties, they can work both ways, under contract to a duty of confidentiality in relation to the receiving and handling of material shared with them. And a breach of that duty of confidentiality equates to a breach of contract. And that can bring with it injunctions in the event a successful claim is brought, and also claims for compensation, i.e. damages. Now, few publishers or producers will agree to sign an author-provided non-disclosure agreement because they're likely to conclude that the legal risks associated with being found in breach are disproportionately high compared with the associated benefit of simply being able to review a submission. However, as I said, it is a high watermark. In most circumstances, it is simply not necessary, as demonstrated in 1982 in a landmark ruling known as the Rock Follies case, where claimants had pitched for an idea for a TV series to Thames TV. Now, Thames TV developed their own version, Rock Bottom, which aired for 2 successful series in the 1970s. And they repackaged Rock Bottom as Rock Follies. Now, the court rules that a valuable idea capable of realization imparted in circumstances where it's intended to be kept confidential between parties will attract confidentiality, even if not expressly agreed in writing at the time of the disclosure. So this leads us onto the question of what you can do, short of entering into a non-disclosure agreement. Now, circumstances do vary and there is no single approach. However, the more steps that you can take to assert that your idea is to be kept confidential, the easier it will later be to argue that a duty of confidentiality was owed. So if submitting a script or a piece of work, label it confidential. For a more belt and braces approach, add a confidential watermark across every page of the script and include some more comprehensive and formal wording in your covering letter. Some example wording might run, I'm submitting this work to you in confidence. This work is confidential and you may not use any of the information or ideas contained within it without first agreeing terms with me, and you may not communicate any part of it or pass it on to anyone else except authorized persons within your company for the strict purpose of consideration for publication and on the same confidential terms. And I cover this and other points in relation to non-disclosure in a blog that we published as part of our Before You Sign series on our website, and I think it's subsequently published in in our regular column in the Writing magazine in, I think, the June issue. So do follow up if you have any other questions about that.
Yeah, that is a worthwhile piece of writing to read, Theo's Before You Sign. So I can heartily recommend it as someone who's read it myself. All I would say is if you are submitting work, do make it very clear on its face that you expect a duty of confidentiality to arise. It really is that simple.
Thank you. In the meantime, you can find the link to that blog that Theo was talking about in the chat in case you want to have a look, and generally to our Before You Sign blogs, because those two contain a lot of very useful information for members. Okay, so next question is, and this one we receive a lot for obvious reasons, is it always necessary to get permission before using someone else's work?
Now, built into the framework of the Copyright Act are a number of exemptions which can, in theory, be relied upon in order to use copyright protected material in ways without clearing permission of the rights holder. And what that means is that rights are not infringed where circumstances apply. And exemptions include the use of copyright protected material for the purpose of quotation, criticism, and review. Now, in all those cases, if you are looking to rely on any one of those exemptions, you will need to show legitimate purpose, i.e., if you're relying on the exemption to quote, you have to show that the purpose is genuinely that of quotation. The material is available to the public. The original work is acknowledged wherever possible, and also that the use is fair. If you are relying on the quotation exemption, which is relatively new to the Act, then there is a fifth requirement, and that is that your use extends no further than is required to achieve that purpose. Again, I'm afraid, well, one of those conditions, just to focus on the fourth condition, that the use is fair. Now, that again is going to be a matter of fact and degree for the courts, and I think many authors can be quite frustrated by the lack of clear guidance on this. What we can say is that generally, whether use is to be considered fair, there'll be two questions that really need to be considered. The first is the amount of the original work which is being used reasonable and proportionate? And secondly, does the reuse affect the market for the work, such that the original creator's commercial interest in that material would be unduly affected? Now, usually it'll be the publishers who handle quotation and anthology rights on behalf of their authors, having taken the authority to do that under the terms of the author contract. And so if you are finding yourself in the position where you are looking to clear permissions, it is best to start with the publishers of the original edition of the book. Many organisations, in an attempt to streamline the process, will have subcontracted out the process of granting permissions to the publishers' licensing services, who can grant them the necessary permissions on their behalf. And indeed, interestingly, some publishers have issued their guidance as to what they might consider to be fair use in terms of any author reusing their material. So it's and if you come to us, we can actually signpost you to that type of guidance on the publisher websites.
Okay, thank you. And yes, in this case too, actually, on our website, you can find a guide to copyright and permissions, and that includes a permission license model letter, which might actually be very useful and very, very handy. Another question that comes up a lot from members and non-members, actually, and even more from non-members who are just starting their careers, is, do I need an agent? And also, then, how do I go about getting one?
Many writers will be looking to secure agency representation at the earliest opportunities. Others will take the decision that actually that's not something that they particularly need or would like. There are many, many more agents that represent fiction authors rather than non-fiction authors. It's relatively unusual for an unknown non-fiction writer to be able to secure agency representation. What we would recommend in the first instance is that writers who are looking to secure agency representation take a look at the membership of the Association of Authors Agents, which is the trade body association for authors agents. Being a member of the association is a hallmark of good standing in the industry and reputation, and members will be signed to the Code of Conduct, which is a kind of best practice framework for the author-agent relationship, and which indeed the Society of Authors helped to draft. More broadly, there is the Writers and Artists Yearbook, which is published by Bloomsbury. Many agents are listed in there with their areas of interest, which in general are quite general. And also they will include information as to how you can submit the listings, those listings, and a lot of that material is available online too, on a kind of subscription-based model. And it's also available in most libraries. When we talk to agents, they almost always tell us that they prefer writers to follow submissions guidance to the letter and also apply to a named agent. They also tell us that there's a lot of internal discussion that goes on at these agencies. So, to make sure you choose the right agent for your book if you can. Perhaps they've got similar authors on their books already. It is fiendishly difficult to actually get a face-to-face pitching opportunity with agents. However, look out for opportunities offered at the London Book Fair, offered by writer development agencies, and also there's an organisation called Bite the Book, which hold ad hoc opportunities to pitch to agents in person. They do, I'm afraid, sell out really, really quickly, but we will flag those kind of opportunities where we can. some members might like to consider self-publishing as a viable alternative if they can't get agency representation. It's not looking that they're going to be able to secure a traditional publishing deal either.
Yeah, and a lot of members actually come to us, come to us and ask, can you help me finding an agent? Can the SOA help me finding an agent? That's not really what we do. And so you should definitely follow the routes suggested by Theo. Do your research, absolutely find the agent that is right for you and that could be interested in what you write. And then we can help you at a further stage when you've made contact. Absolutely do come to us. We can help you with agreement. We can help you with just even dealing with them and just clarifying any doubts. Anything to add, Addy, on this?
Well, I think Theo's distinction between fiction and non-fiction authors is a really good one. And for those authors for whom they feel an agency route is right for them, all I would say is go on to the Association of Authors Agents, the AAA website, and have a quick read of their code of conduct. I was sad enough to do so earlier in the week. And the code of conduct itself it's very easy to read, it's very clear, and I think having read it, if you are considering that route, you'll be left in no doubt that these really are de minimis standards to which any reputable agent should be expected to work. I mean, for example, clause 4 of the code of conduct says that the agent will account to the author within 21 days of having cleared client monies. These sorts of things we would expect to be adhered to on the part of any good agent. So do give it a read, and by all means, you can always follow up with our advice team if you're at all unsure.
Thank you. And we continue with a big one. So a publisher has sent me a contract, so a classic. What's being proposed? What are the basics, or what sort of deal I'm being offered? What am I entitled to as a standard?
Well, broadly speaking, Nadia, there are 4 sorts of deal that we're observing in today's industry. The first is self-publishing. The second is traditional publishing. The third is minimal investment publishing. And the fourth is where an author is asked to pay, or at least pays to some extent. Now, the first 2 categories are relatively self-explanatory by their headings, and the third and fourth less so. So just to start with category 3, which is the minimal investment publishing, we have long campaigned for fair and appropriate contracts as part of our Creator campaign, covering issues such as transparency of accounting, fair remuneration, and the exploitation or else the reversion of rights acquired. Now, these asks take on a new significance where the publisher is bringing lesser value, whether across the editorial handling, the production, or the promotion of your work, to the collaboration they would have historically. Whilst we do recognise the inherent value to being published, we would always encourage writers entering into a minimal investment type arrangement with caution, and to explore opportunities to self-publish for a very useful context. Now, just moving on to the fourth category, which is where the author is asked to pay, at least to some extent. Now, this is the more complex of all the 4 categories, and where I think we at the SOA have the most concerns. Now, the basic principle here is that if you are entering into a partnership type arrangement, as those types of arrangements are often referred to, with the publisher and making an investment towards, for example, costs associated with the editing, printing, or promoting of the work, then it really should be clear what the publisher is bringing to the table, so that questions relating to the control of rights and share of income can be discussed and decided fairly. Now, our view, I think, is that it should be clear whether both the author and publisher are sharing risk on account of future earnings on sale of the work, which is the traditional publishing model, or whether the publisher is in fact turning a profit on the investment made by the author. Now, the current landscape is complex with a wide variety of opportunities on offer, so we would urge you to share any questions that you may have or paperwork that may be presented to you with one of our advisors by contacting us at the info@societyofauthors.org.
Yeah, absolutely. I mean, if you're a member, please use your membership, especially for contracts. Just get everything checked before signing. It is very, very important. We repeat it constantly to our members. And as soon as you send it to the info inbox, we'll give you an answer, just confirming that we received it. And usually our advisors get back to you within 5 to 10 working days. If it's urgent, you can say it in the email, but also usually a good publisher should give you enough time to review the contract and check that everything is okay. So if they start pressuring you, also do pay attention to that and do tell us that, because it's important to know. And it could be a sign of something. It might not be, but they might just be in a rush. We never know, but just in case. And another thing is also many members do get in touch on the phone just asking, oh, can I speak to an advisor about my contract? We usually have to ask you to send in an email, because our advisors do need to check the contract. That requires time and focus, and doing it on the phone, it's not as easy. And they can give you the best advice actually looking at the contract and writing an email, where you can go back to the email anytime, and it'd be just more useful for you. Eddie?
I think you make an excellent point, Nadia, about the importance of getting documentation signed, checked before it's signed, and also giving as much time as you reasonably can to our team to ensure that they have the space to check through documentation well in advance, ideally, because many of the issues that we're talking about are not readily digestible or particularly conducive to being explained in a quick telephone conversation. Perhaps if I could just touch on the fourth model that Theo mentioned. I think it's particularly important where you're being asked to pay, to think very clearly about what your expectation is from the agreement and how you think that sits next to the publishers. Think also very clearly about what you're being asked to pay and what you're likely to receive in return. I think that's vital with any contract, but particularly with a contributory or subsidy publishing contract. And closely linked to your own expectation, when are you likely to have that work published? Some contracts, I think it'd be fair to say, we found contain some overly long periods for producing the work, which is a concern for us, and is inevitably a material concern for the authors themselves, who quite reasonably want to have that work out there as quickly as possible. I think as well, you need to think in terms of what you're being asked to give up in terms of your intellectual property and copyright in particular, and what rights of reversion, if any, you have, and what termination provisions there are in that contract in the event that you feel badly served by it for one reason or another. So, I mean, there's a lot more I could say, but I think for our purposes here, given that time's marching on, that's probably where I would draw the line. But suffice it to say, do please get in touch with us, and do please do so with as much advance warning as you possibly can.
Thank you. In the meantime, Emma has asked, does the contract checking service you provide also apply to agents' contracts? Yes, absolutely. That is also something we do, so feel free to send that too. So another question is, I've been asked to assign copyrights and waive my moral rights. What does that mean, and should I agree?
Well, Nadia, the Copyright Designs and Patents Act of 1988 does allow you to license or sell your copyright. An assignment is that sale. It's a transfer of ownership. The assignee, the party to whom rights are assigned, will become the new legal owner and will be able to adapt your work and make use of it howsoever they please, subject, of course, to any terms and conditions that you have agreed to have govern the assignment, e.g. the terms of your publishing contract. Now, an assignment can be total, so relating to all rights that are reserved to you under the Act, or partial, so limited by scope or duration. And moral rights are a subset of copyright, and they include the right to object to any derogatory treatment that may be prejudicial to your reputation as an author of your original work, and a right to be identified as an author, as the author of the work, I should say. Moral rights cannot be assigned or transferred under UK law, although they can be waived. And in fact, there is a requirement that in order to be identified as an author, in order to assert that right, in order for that right to arise, you do need to assert that right in writing before it applies. Easiest way to demonstrate this is if you open up any kind of book that you might have to hand, look at the title verso page and you'll see the wording, name of author, hereby asserts their right under the Copyright Design and Patents Act 1988 to be identified as the author of this work. Now, significant to moral rights in terms of an assignment of copyright is that very often the new owner will ask you to waive your moral rights so that in particular they can be sure they're able to freely dispose of that material. And it's our view that assignments of copyright are only appropriate in the very narrow set of circumstances, and moral rights should only be waived to the extent that may be essential. The threshold for a moral rights infringement claim to succeed, in terms of the moral right to object to derogatory treatment at least, is relatively high. And so most publishers acting within the usual industry norms and practices should not really be unduly concerned. And at the same time, it is reasonable for an author to expect for even this level of protection to be reserved if in the unlikely event it ever needed to be relied upon. So if a publisher or any other third party does insist on an assignment and a moral rights waiver, then you do want to ensure that so far as is possible, the significance of what this will mean is tempered by the terms and conditions of the assignment. A contractual right to be credited, a right to approve or be consulted over certain adaptations or alterations, a right to be involved in any revising of the work for a new edition, a right to approve or be consulted over the use of your material in another work. On a perhaps more technical level, you'll also want to ensure that rights will be assigned back to you in the event of the publisher's bankruptcy, and ideally ensure that the assignment is conditional upon you being paid. If you have been asked to assign rights or waive moral rights in your work and would like us to offer a fact-specific commentary, please do share more details on your query as well as your contract, if applicable, to us at the info address, and one of our advisors will be very happy to get back to you.
Thank you, Theo. Eddie, do you have anything to add on this?
Well, there's not a huge amount for me to add. I think that was an excellent explanation, very comprehensive, setting out what the issues are. I mean, just to digest it, perhaps for members, I like to think about two broad umbrella rights that you have. On the one hand, you have the economic right to exploit and make money from your work. Okay, and you can effect that by retaining the ownership of it and licensing, granting licensing over your works, or on the other hand, assigning the copyright and thereby, as Theo rightly says, effectively transferring the ownership of that. And do remember that this doesn't apply to authors who are working in the course of their employment under Section 11 of the Act. So paid in-house authors or journalists are in a slightly different boat in that regard very often. Moral rights, on the other hand, interestingly, they can be waived, as Theo says, in the UK, but in other civil law jurisdictions, France, Italy, Belgium, for example, they're inalienable. They can't actually be waived or derogated from in any sense. And really, the moral rights are there to really provide a backstop, if you like. So you have a right to be identified as the author of a work on the one hand. You have a right to object to any derogatory treatment of that work by someone else. And equally, you have a right against false attribution, which is increasingly important in this world of fake news in which we live. If you are interested, do give Section 77 to 83 of the Copyright Act of 1988 a read. They're actually quite clear sections of the law. So if you are curious or just suffering from insomnia tonight, do give them a read.
Thank you, Eddie. So another one. My work hasn't been published on time. What can I do? Eddie,
Yeah, if I feel that one, Nadia, I think it'd be fair to say that delays are a common source of frustration and a key source of disputes in many contracts, and publishing contracts are no exception. Perhaps if I just explain the difference between time of the essence clauses and other time-related clauses in a contract, and why there's a bit of a cautionary legal tale here. I'll try not to get too techie, and do rein me in, Nadia or Theo, if I do get overly nerdy. But in clauses where time is of the essence, failure to perform an obligation will put the publisher in breach of that contract, and it will entitle an author to terminate the contract and claim damages. But that's highly unlikely to be the case, not least because courts will often enforce these time limits very strictly, and therefore publishers really have no incentive, I'd suggest, to offer them. So other time-related provisions that you may see in your publishing contract, very often they won't be time of the essence clauses. Okay, so what that means is that any obligation that follows from that really will have to be performed within a reasonable time, which of course will depend on the facts and the circumstances of each case. So in the legal jargon, such breaches by a publisher, for example, will not be considered repudiatory. So they won't entitle an author to terminate a contract very often. The author has instead to make a claim for damages for losses caused by the delay, which itself can be quite tricky to prove. So there's also the matter of publishers' unreasonableness to consider, which is a slightly separate issue. If a clause isn't a time of the essence clause, and a publisher really has unreasonably delayed in making good, then the author can usually serve a notice making time of the essence. Okay, and what that will do is require the contract to be performed within a reasonable time, and state on its face very clearly that failing to comply with the notice will then result in the contract being treated as being at an end. The cautionary tale, or the sting in the tail here, is that in issuing a notice, really, you should consider that something of a nuclear option, because by definition, the contract would then be considered as being at an end, which may affect an author's rights and obligations otherwise. Okay, so if in doubt, and again, this is a bit of a common theme, do consult our team, and do so, well before you think a problem is likely to arise, if at all you can.
Yeah, absolutely. So we're on the last 3 questions. We probably have to be brief to leave some time for the questions from our audience. But another frequently asked question, unfortunately, is my publishers haven't paid me. What actions can I take?
Yeah, I can step in here, Nadia. A couple of headline questions to ask. Is the fact of the debt clear and unambiguous? For example, an advance agreed upon signature may well be quite clear, might be very well be clear there that there's a debt owed. An advance due upon the publisher's acceptance of a script may be less clear. Is the contract governed by UK law? Indeed, if there is a contract, obviously these broad principles cut across so many different types of arrangements where a writer is being commissioned or work is being purchased by a third party for publication. Because under UK law, there is a right to levy interest. Now, that is something that you can use if you were to go ahead and make a claim in the judicial system, or you can also use it to motivate the publisher to settle the debt. Because one of the things that we find is that if you make it a little bit cheaper to pay, make it as easy as possible to pay, that can be a key motivational factor in that debt being settled. There is a distinction here. If you are looking to take matters forward and submit a claim, a legal claim, you are advised in the first instance to draw a distinction between publishers that may not be able to pay and those that aren't paying. If they can't pay, what you can do is to apply for a statutory demand and then to make them bankrupt or have the company wound up. However, the costs associated with this are high and you may not get your money back. If the company has already entered insolvency proceedings, then you would need to register your claim with the insolvency practitioner. And unfortunately, it is likely that you will become relatively low in the list of the creditors who are sort of paid off. The debts are all set out in accordance with priority in what is quite a very regulated process. But yes, if they won't pay, then you have that right to chase debt, and you can submit a claim via Money Claims Online, which is the government portal, which allows you to chase a debt of up to £100,000. If it's less than £10,000, it would be diverted down the small claims track. You do need to make sure with any of these claims that you adhere to a number of pre-action protocols. This includes giving the debtor full details of your claim and the opportunity to pay within a given time limit, and confirming that you will take action if the debt is not settled within that period. For the small claims track, as I said, the claim does have to come in under £10,000. And the great benefit of this small claims track is that the costs are limited to the court fee and a few other expenses. There's no risk if you claim down the small claims track that you are going to be liable to pay the other side's legal fees. In fact, there will rarely be a lawyer actually involved in the process. So it is worthwhile logging onto the government website for some more information, or of course ask one of the team if this is something that you would like to know something more about. Now, just an NB, if the dispute relates to questions of copyright, i.e. infringement, you'll need to use the IPEC small claims track, which is a different court, and it's overseen by experts with, legal experts with experience in the very complex framework of copyright.
Thank you, Theo. Eddie, did you have anything to add on this?
Well, I mean, I could go on ad nauseam, but Theo's given a very quick and comprehensive summary again. So suffice it to say, do get in touch with our team, not least because before you go down the stat demand route in the case of chasing a debt, for example, you'll probably want to write to the publisher or whoever, whichever third party owes you money, frankly, to try and cut a deal. The MCOL route, that Money Claims Online route that Theo mentioned, is a good one if it is a straightforward debt to be chased. A word quickly on the statutory interest. People do tend to get quite excited about this, but I did a fag packet calculation earlier in the week, and for a debt of £1,000, given how low the Bank of England base rate is, you're talking about a whopping daily interest rate of 22p. So as ever, pragmatism is probably the order of the day, and as I say, taking that advice from our team as soon as you possibly can.
Thank you. Right, so last two questions. I am writing my will. What happens to my copyright, and do I need a literary executor? I think this one for you, Eddie. Okay,
well, I can give you a very, very quick answer on this. The short answer is no, and I would strongly suggest anyone tuning in to have a read of our Before You Sign blog from the 11th of February of this year, in which we discuss the need or otherwise for literary executors in some depth. And just for the avoidance of doubt, I joined the SOA on the 17th of February, so I didn't write it, but whichever of my colleagues did a fantastic job, because I agree with every word.
Thank you. And also, just so everybody knows, estate owners can join the SOA. They can be members of the SOA and then ask whatever questions they need, just in case this is needed. And they can also take over the membership of a previous member. So we will have all the information that they sent us up to that point as well. That can be useful. Last question is a very, very contemporary one. My publisher has terminated my contract because of COVID-19. What are my rights?
I'll chip in here as well, if I may, with a very short response, just to say, if you go onto our coronavirus response web page, you'll find a very comprehensive set of FAQs setting out all the things you need to consider if indeed you're on the receipt of a terminated or an ended contract. Okay, so do give that a read. There's also a before you sign that I think is now up and live, if that's correct, Theo, on the same subject. And I do declare an interest here. I did write those documents, so if in doubt, if they're at all unclear or you're at all unsure, do get in touch with our team, and it will invariably wend its way through to me, and I'll see if I can help.
Thank you. So those are the most asked questions. Of course, there are more, but we chose 10. I think we're a bit late, but I think it's worth looking at some of the questions that came up in the chat during the event. So Julie asked regarding quoting other people's rights and copyright. What about TV who rip off historians' work and do not acknowledge where the original idea came from? Is there anything that can be done if that happens?
Yes, I don't know, Judy, if you were in attendance at the event we hosted, I think 2 years ago now. We were in the room with Business Affairs executive from PACT and also a couple of lawyers from the BBC. And further to that, and we had quite a significant discussion on exactly this point. Further to that, we drafted a code of practice, again, which we agreed with PACT, which is the Association Trade Body for Independent Producers, which was designed to show that it was designed to help where commissioners or producers were phoning up historians on the expectation by the historian that they were going to be involved in the program. Suddenly 30 minutes had elapsed. The historian had spoken at length. The producer had decided that contribution was enough for them, and they were going to take forward bits and pieces from that and use it in the program. The historian did not then get the opportunity to be involved. So that was something that we put together to cover the process of historians and expert contributors working together with producers. Yes, of course, where a producer is instead reading a book, ripping off the idea, that's hugely concerning. And what we're trying to do, and I'm secretary to the Scriptwriters Group, is all the time establishing relationships, understanding who in the industry we need to speak to, making sure that they have an understanding who we are, so that any concerns can be raised directly with them. And if there's any kind of wider or wider messaging that we can put out publicly on this, then we'll certainly be looking into that as well. So do get in touch more with your concerns, but it is definitely an area of massive concern for us.
Thank you. There is another interesting question here. Mia says regarding copyright again, if it is an impromptu speech at an exhibition or available on transcript, as in at Parliament, There is no copyright issue in transcribing parts of the speech. And in the case of the impromptu speech, the name of the person speaking is stated in the novel. So I understand it would be okay, but good practice would be to let the artist know. Is that right?
The use of impromptu a contribution.
And it comes from an impromptu speech at an exhibition, specifically.
Well, I mean, it's arguable. Where you see this touched upon predominantly is where you're having in the area of oral history, where people are going around recording people's articulated experiences in order to take that forward and either use it as part of your research for your book, or actually transcribe it and actually quote it in your work. Yes, I think there may well be copyright in those contributions. It will arise the moment that recording is made, and as a result of that, a lot of the time you see authors undertaking this type of research asking the contributor to sign a moral right, an assignment of copyright,
right,
to cover themselves, or and also a moral rights waiver. So you do see those two together in that area of the industry too.
Perhaps if I give a massive nerd alert here, have a read of a case called Walter versus Lane. If you just Google it, Wikipedia actually has a fairly helpful summary of the case. It was a case under the Copyright Act of 1842, but it related almost identically to the example given by a member in the question, Walter versus Lane.
Thank you. I can see that a lot of people are asking questions about contracts and what's the standard in agent contracts, publishers contracts. I think that's a bit too long to discuss now. I would definitely invite you to look at the guides again, because we do have a guide about what kind of contract you've been offered. And then again, I know we've repeated this a lot, but do get in touch. Just get it checked. I would suggest that always. But there is a question I think we can ask quite quickly, possibly. So Becky says, I'm about to have a book published later this year and would like to know about details regarding it going on to Kindle as well. Is this two different contracts?
Generally speaking, a publisher will take ebook print volume rights, and actually that's a best practice because that's a relatively narrow scope of copyright. In practice, you do see a much wider copyright grant. So yeah, so what you'd expect is for the publisher to take print rights and also the electronic rights to make available an electronic reproduction of the print book. So that's verbatim ebook. It wouldn't allow them, for example, to make an app or to cut it around a bit and kind of create all these kind of crazy electronic products that you do see in certain areas of the industry. But yes, you would expect that to all be drafted up onto the same contract.
I would just say here, beware of overly nebulous wording as ever in any contract, but those rights should be as specifically expressly granted as possible. And if in doubt, of course, take advice from our team.
And still related to contracts, as someone says, I'm able to write in 3 languages. Should I have a contract with a publisher by language territory? Is that...
You want to fill that one, Theo? It's a great question.
It is a great question. So what generally happens is that a publisher will take the right to publish the work in its original form, but also the right to adapt the work or sell the right to adapt that work into translation. So what you'll be looking at there is what are the language expectations in terms of the actual work, and if you're going to be the one to either allow them to publish in a variety of languages, but all based on the original material that you provide to them, and then that's very, very different to saying, well, actually, you can adapt this work for translation, and by the way, I'll be the person that translates it. But you, generally speaking, with ebooks, if these are going to be available electronically via a digital platform, and they would probably be, whichever language they were looking to publish in, they would be looking to take global rights. And it's very different when you're talking about print products, for example. But also it does depend a little bit on the territory as well.
It's all a matter of degree and control, I think. So it depends the extent to which, if our member is producing a piece of work in language A, whether he or she also wants to have a first refusal or a monopoly right, if you like, on also translating those works into languages B and C, if that makes sense.
Yeah, thank you. That was really interesting. One last one, and then we close the session. Brian says, from memory, I think I had to indemnify my publisher if someone decides to sue. Is that right, and is it fair? He specified he's writing non-fiction.
Well, so generally speaking, the warranties, which are contractual promises, but they're given a higher sort of a higher degree of importance within a contract. You will be asked to promise that your work is original, your original work, that you and also that it is not libelous or otherwise unlawful. Now that is the sort of entry position, because what a publisher will do is to expect for you to be aware of any major legal issues with the work and to raise those with the publisher if they're appropriate. So for example, if you are best placed to know whether you've based a character in your fiction work on someone that lives next door to you, in which case there might be potential issues. But what that does mean is that if there are issues that you are concerned about, it is so important to have a full and frank discussion with the publisher, because there are very often steps that can be taken to mitigate any risk, and it certainly shouldn't be you who are in the position of not only risking being in breach of that, being asked to make promises that you can't fully substantiate, but also very often they will be twinned with a promise to compensate the publisher in the event that they're taken to court and they suffer loss as a result of your promise not holding true. So it is really important that those risks for every party are discussed. And what will usually happen is that the publisher will have, as standard process, an insurance policy just in case things go wrong, something slips through. And so the discussion that you would need to have is to make sure that your work was included under the terms of that policy, and also ideally also your liability, so that if someone brings a claim against you, then that will be covered. But those are issues that can be discussed quite openly, actually, and it's in the best interest of all parties for that to be the case.
Thank you.
I think it's a case of reasonableness and proportionality. We do have an Unfair Contract Terms Act in this country, long established, and there is an express protection in law against blatantly unreasonable indemnity clauses. But again, if in doubt, do take advice before you potentially give any indemnities that are not otherwise provided for on the face of your publishing contract, for example.
Thank you. Well, thank you, Theo. Thank you, Eddie. And thank you, everyone. There were loads of interesting questions. I'm sorry if we couldn't answer all of them. We're really running out of time here, but feel free to continue this conversation on Twitter. The festival hashtag is #SOA@home. If you have any questions that are specific to you, feel free to email info@societyofauthors.org. We're more than happy to answer. And yeah, there's another event tomorrow, actually, the last one of the festival. It's an afternoon tea with Joanna Trollope at 4 p.m. And please head to the website to register for that. As I said, all these sessions are free. If you can spare a few pounds for the Authors Emergency Fund to support other authors in financial difficulty, please follow the link at the top of the chat to donate to the fund. So yeah, thank you everyone. Thank you, Theo, again. Thank you, Eddie.
Thank you.
And yeah, thank you for attending this event. I hope it was useful for you, and I hope it gave you some guidance, but also inspired you to just write to us for any question you might have. And we hope to see you tomorrow at the Thursday afternoon tea.